If you are buying, selling, or investing in real estate, it is not just about only find the right property. It is about protecting yourself as well. Real estate deals are legal contracts, and when something goes wrong, like buyer backing out of the deal or seller refuses to hand over the keys to new buyer, it can be messy fast. That is why today I am bringing a litigation lawyer, Weston Powell, to break down what can go wrong and, more importantly, how you can avoid it or protect yourself.
Hey Weston, tell me a little bit about your service, and because my audience is definitely get a lot of value from this discussion. So please tell me a little bit about you and your firm and what you do for the clients. Yeah.
Absolutely. Well, thanks for having me, Gavin. It's good to be here. I'm a litigation lawyer. So I do lawsuits exclusively. I don't do transactional work. I don't do closings. I'm not the lawyer to call if you need to buy or sell a home, for example. I'm sure Gavini can introduce you to any of a number of great real estate lawyers. What I do, what my firm does specifically, is litigation. So lawsuits. Specifically, we do a lot of real estate litigation. So we've been at it over a decade. Powell Litigation currently has 7 lawyers, a bunch of support staff. Our offices are in downtown Toronto at the corner of Bay and Richmond. And we serve the greater Toronto area. So not just Toronto, but as far north as Barrie and east to Oshawa and all these different far-flung places. Happy to help people. The problems that we solve mostly, like I said before, real estate litigation. So something that I see a lot of are failed closings. It can be that someone is coming to me because they bought, for example, a pre-construction condo, and they're concerned that their circumstances have changed such that they're not going to be able to close for whatever reason. They don't have the financing, or they lost their job, something's happened, and so they won't be able to close. And so I can walk them through what that dispute would look like. I can also act often for sellers. Believe it or not, in the resale market, sellers will often approach my firm and say, we had a deal, it was firm, and then on closing day, for whatever reason, the buyers were nowhere to be found. What do we do about this? And I'm able to provide results and, for one, get them the deposit that they're rightfully entitled to. But now if they later sell their home to somebody else for a substantial diminishment in sale price, I can go after those would-be buyers and sue them for those damages. That's a very, very common lawsuit that I'm involved in on a day-to-day basis. Beyond real estate litigation, we also do corporate commercial disputes. So if people are owning a business together and they're having a falling out, maybe someone's taking money that they shouldn't be taking out of the business, or somebody bought a business and there were certain representations that were made that turn out not to be true, my firm can certainly help with that. So long story short, we're a litigation boutique. We help solve people's problems in court.
I mean, it's a great topic. I think a lot of people will see a value on whatever you're going to share with them. And first we take buyers as an example. So how they can avoid going through that kind of, I take it a hassle because nobody's expecting to go through that process. Mm-hmm. So say as example, someone is buying a home, how can they avoid happening that kind of situation in their life?
Yeah, absolutely. So I guess there's a couple of things, right? So one of those common scenarios that I see is when buyers are in a position where they're failing to close. So ideally, you want to avoid that circumstance altogether. And the best way to do that from a litigation standpoint is not to waive your conditions on your offer until you're satisfied that you can, in fact, secure financing. And so that obviously you're going to be speaking to your audience now, Gamini. You're going to want to work very closely with your realtors, because realtors also can explain to you, well, listen, there's a time to make an offer with conditions and there's a time not to make that. And that very much depends on what's going on in the market. Mm-hmm. I know that at different times there are markets, for example, where if you make an offer with any of a number of conditions, you don't stand a chance. You're not going to be selected. Yeah. I don't know what's going on exactly in the market today. I don't think it's quite, I think it's more of a buyer's market. Mm-hmm. You could correct me on that if I'm wrong, but I think there's nothing wrong probably with making some conditions in your offer. And so just, working with professionals like Gamini and making sure that you understand what it is that you're signing on to. If you do make a firm offer, and by a firm offer, I mean an offer that has no conditions, no inspection condition, for example, no financing condition, there's nothing wrong with making such an offer if you understand what it means. And what it means is if somebody accepts that offer with no conditions and you put down a small deposit, if you fail to close, well, you're going to lose that deposit more likely than not, and you could potentially be sued. So I guess the best way to avoid a litigation or a lawsuit in the first place is work with great real estate professionals, understand what you're doing, go into it with eyes wide open, and don't write checks that you can't cash, so to speak.
Right.
That's with respect to failed closings cases. Another thing that, speaking of buyers, something that I often see is they'll buy a home, and then after closing, for example, they'll discover some things that bother them. So one thing that I see quite often is you buy a property as a purchaser and you're expecting it to be vacant. That's what's on the boilerplate agreement of purchase and sale, right? It says specifically that vacant possession shall be provided unless, the document elsewhere says something otherwise. And so one thing that I often end up having to deal with is where purchasers are trying to buy a property and the sellers are trying to get the tenants out. They're doing everything within their power. But as you know, sometimes tenants can really blow things up. They can screw up the deal because they refuse to leave, for example. And even if they're served with the proper paperwork. And so if that's a situation where a tenant is refusing to leave, the only way lawfully to remove that tenant from the premises is with an order from the landlord tenant board. And the problem with that is getting those hearings, it changes all the time. And candidly, that's not actually an area that I practice any longer because it's just too much of a kangaroo court. There's plenty of great paralegals that can help you navigate that process.
Right.
But my understanding is it takes at least 4 to 6 months before you get such a hearing. And so if you've only got a 2-month window for closing, and then that 2 months goes by, but the tenants haven't left, well, they might not have to leave for another 4 months, for example. And that's assuming everything goes well. So a question I get quite often is, well, I bought the property and the agreement of purchase and sale is a boilerplate agreement of purchase and sale that says that it's supposed to be vacant, but it's not vacant. Right. Do I have to close? As the buyer, do I have to close on this property? This is a really interesting question because if you Google this, I won't name them, but another law firm's blog post will appear. And candidly, it's wrong. That blog post is wrong because what it says is that, basically, you as a purchaser always have to close, even if it was supposed to be vacant. And if you fail to close, you're going to be in heaps of trouble. And here's an old case from the divisional court from 30 years ago that basically says that. And the case that they're referring to, it is good law. It's a perfectly fine case. But what happened in that circumstance is that a purchaser was going to be buying a property and it was supposed to be vacant. And this is 30 years ago when the lawyers actually had to physically attend a land registry office to close on a deal, right? And so it's around 4:00 or something, and the tenants haven't left, but they're literally in a moving truck. Like they're in the process of moving out. But the buyer says, well, technically they're not out yet. And so I'm not going to close because my agreement of purchase and sale says I'm supposed to get it vacant. You haven't provided it vacant. I'm not closing. What ends up happening? The seller, obviously very upset, says that's a technicality. They were on their way out. They were literally in the driveway. No. And so the seller sues the buyer. And wouldn't you know it, the seller is successful. The seller actually does win the lawsuit. And the judge says, you know what, buyer, you should have purchased the home. And so what that case stands for, in my opinion, is that, as a buyer, you shouldn't rely on a technicality. If the tenants are literally in the process of moving out, if they're in the driveway backing up, you should probably close. Otherwise, you're taking a real risk. But it does not stand, that case does not stand for the proposition that you should always close if the tenants aren't leaving. And I say that because I think something like 20 or 25 years later, another case came out, very similar circumstances. A buyer bought a piece of property. It's supposed to be vacant. It's not. The buyer made it clear in advance, I'm going to live here. So obviously it has to be empty or I'm not going to be able to move in. And the seller says, I tried, I did everything within my power, but I'm sorry, I can't get them out. What ends up happening in that case is the buyer says, well, I'm not closing right now because that's not what I bargained for. And they don't close. And then a year goes by and the buyer sues the seller and says, you know what? I want the house that you agreed to sell me and I want it at the purchase price we agreed to and I want it vacant like I was supposed to. And wouldn't you know it, the judge sides with the buyer. So basically what all this means is we've got two different cases involving similar circumstances.
Right.
The first case basically means you as a buyer shouldn't try to get away with a fast one. Like that wasn't even the real reason why the buyer didn't close. The buyer just didn't want to close on that transaction. He was trying to find any reason why he could get out of it. And the judge said, no, you know what? You should have closed. The second case is very different. The second case is a case where the tenants were never going to leave. They weren't in the process of moving. It wasn't vacant, period. And so in those circumstances at law, no, you don't have to close. If you sign an agreement of purchase and sale as a buyer that says that it's supposed to be vacant, and then come closing day, it's clear the tenants are going nowhere, you're not getting a vacant possession. In my opinion, no, you do not have to close on that property. You have other rights that could be available to you. You should consult with a litigation lawyer and figure out where you stand. But those are two problems that I see quite often. And my heart bleeds for the sellers, candidly, because it's not their fault, right? I mean, sometimes tenants just do the wrong thing. They can get served with all the right paperwork, an N12, in this case, a notice called an N12, that says that, hey, I've sold the property, they're going to be living here, they've sworn an affidavit that they'll live here for a year, you've got to go. And the tenant might just not leave, right? And if that happens, well, now the seller has to go take them to the landlord-tenant board, and as we discussed, that could take many, many months, and it can blow things up. And an interesting aside, a lot of people don't know this, but sellers in that circumstance, because I get this all the time, a seller will come to me and say, hey, I've sold my property, but the tenant is blowing up the deal because they refuse to leave. Can I sue the tenant? Can I sue the tenant for blowing up my deal and causing me all these problems? Believe it or not, the answer is no. There's case law that says that there's nothing wrong with a tenant exercising their right to go to the landlord-tenant board. Even if they know they're going to lose, there's nothing wrong with them, dragging their feet and waiting until they get their day in court at the LTB. And so this case has actually been tried before, and landlords and sellers have lost. So it's very, very frustrating. We live in a very pro-tenant province where the balances are very skewed towards protecting tenants rather than landlords. Anyway, that was a big spiel, but
no, I mean, it's a very important point that you made. So if a buyer is buying a tenanted property, if property is not closed on the closing day, so you mean to say that buyer can walk away from the deal?
Yeah, so basically if a buyer, in their agreement of purchase and sale, it specifically says, and this is the boilerplate language, that they're buying it vacant, that vacant possession shall be provided. Yeah. And then they discover that on closing, it's not vacant. Mm-hmm. Yes, they can walk away from the deal. They can basically terminate the agreement, and they should be able to get their deposit back. Now, as you know, that can get a little bit complicated, right? Because the only way to get a deposit released to anybody is either an agreement in writing between the two parties, the transaction goes through, obviously, or somebody goes and gets a court order. And getting a court order can be expensive, as we may end up discussing today. So they might have legal rights, but enforcing those legal rights can be sometimes difficult and expensive.
So if the seller is not signing the mutual release, so they have to go through the court to get the deposit back?
Yeah, unfortunately. And so we've dealt with that on both sides, by the way. Sometimes we're acting for sellers and sometimes we're acting for buyers.
Right.
But if the two of them can't work it out with a mutual release, then yes, the only way to get the money released to anybody is going and getting a court order. And so that's something that I struggle with. Often sellers are kind of convinced by their realtors or their real estate team. Sometimes their transactional real estate lawyer will convince them to sign a mutual release, right? Saying, okay, I wash my hands of this, and maybe we split the deposit, or maybe the buyer gets some of the deposit back. And I get frustrated when I hear that, because legally speaking, the seller, if the buyer, and it's usually the buyer that breaches, right? It's usually the buyer that fails to close. If a buyer fails to close on a firm deal, the seller is 100% entitled to that deposit, period, full stop. And so I don't know why so many people will just give the deposit back or share it or something like that. I appreciate nobody likes going to court. And a big part of what I do actually is trying to talk people out of going to court, because it can get so expensive. But for something like a deposit, it is so straightforward. We can bring an application, we can get the entire deposit released to the seller. You don't have to negotiate. And I guess this is a huge message, a huge takeaway for your audience, sellers specifically. Don't sign a mutual release until you have a lawyer review it. So don't just rely on your realtor. Don't just rely on your real estate transactional lawyer. Go talk to somebody who actually litigates for a living and understand what it is that you're signing, because I can't tell you the number of times where a seller, the buyer fails to close and it's a firm deal, but the buyer fails to close. And maybe there's a $50,000 deposit, sitting in some trust fund. And everyone convinces the seller to sign a mutual release where the buyer gets back half the deposit, they get 25 grand, the seller gets 25 grand, and they've washed their hands of it. But here's the problem. If that seller now goes and has to sell the same house that, as an example, that buyer was going to buy for $1 million, just as an example, well, what happens if now that seller has to go sell the house for $900,000, $800,000, right? Like, what if there's a huge diminishment in sale price? If that happens, you've already signed the mutual release. You can't do anything. You can't sue them. You can't get that money. And so it's not something to be done lightly. Like signing a mutual release, you are giving up all of your rights. And so at a minimum, you should be consulting with a legal professional to understand what it is that you're giving up. And sometimes it makes sense. You know, if you already have another buyer lined up and they're going to buy it for the exact same price, sure, no problem. But if on the other hand, you don't know, like you don't even know if you'll be able to sell it, why would you let the defendant out just because you're a nice person? I get it. Canadians are very nice people, but you've got to look out for yourself too, right? And make sure that you're protected.
Say, as example, if buyer breaches the contract,
Yes.
and say in this case, if seller is not signing the mutual release, still the seller can go and sell this property to somebody else?
Great question. Great question. Yeah. And a lot of people get this wrong. And I think that's why so many people are convinced into signing the mutual release in the first place. Often the brokerage, for example, might get this wrong. They might say, well, hey, we need you to sign the mutual release because otherwise we can't list the property, we can't sell it, blah, blah, blah. That's not correct.
Okay.
At law, every real estate transaction, time is of the essence, meaning the day that they failed to close, right? If closing is today, the 24th, and they fail to close, the very next day, I can terminate that listing, I can relist, I can go sell it to somebody else. I don't have to wait. I don't have to see what the other side was going to do. I don't have to get a mutual release signed with them. I, as the seller, can do whatever the hell I want. It's my property. And so if you get any pushback from your realtor or your brokerage or whatever, you need to understand that's not good advice. You are absolutely allowed to. And it might be a little bit of paperwork for the brokerage, but legally speaking, absolutely. A seller can go and sell without a mutual release.
What you're saying is pick up the call and call Weston.
Yeah, absolutely.
Yes, get it. I think now, assuming that the property is tenanted and the seller is not able to vacate the property because tenant is not leaving, so buyer can wait. If they want to wait, can they wait as long as they want and still seller has to sell the house?
Yeah, good question. So if this happens all the time, right? This is just a part of life. Absolutely, the parties can agree to extend closing, but both sides have to agree. The buyer, for example, can't demand that closing be extended. The seller, as usually the seller, if they're the ones failing to close, they can't demand that the deadline be extended, that the closing date be extended. But if the two parties can come to a mutually agreeable solution, there's nothing wrong with that. In the case that I mentioned, where the seller was unable to close because they couldn't get the tenants out, and the buyer said, well, I'm not closing then. What happened in that case was much later, the buyer forced the seller to sell him the home again. It was a new transaction, and that new transaction was brought about by the court. The court said, yeah, you have to sell him the home at the agreed upon purchase price and vacant, just like you agreed upon. It's called specific performance. It's when the court gets someone to do an exact thing.
Okay, so it means if buyer still want to buy that property, they can wait as long as that property will be vacant.
Yeah. So you run a risk here. There's the possibility that the seller could go sell the property to somebody else, right? And so one of the tools in our toolkit as litigators is sometimes we can basically freeze a property. And so there's different things that we can do. The most common is something called a certificate of pending litigation. And what we do is we start a lawsuit and we bring a motion, and within that motion we request something called a certificate of pending litigation, which is basically, you can think of it like a lien. It's something that gets registered on title to the property, just like a mortgage effectively, and it stops anyone from buying the property, because no one in their right mind would buy a property that has a CPL on it, because that CPL means, hey, we don't know who's going to end up owning this property. Right? That is a live issue right now. And so in one way to protect yourself as a buyer in that circumstance is if you have a litigation lawyer behind you, you can register a CPL. To get a CPL registered, you do have to have what's called a proprietary interest in the property though. So that's something I get quite often. Sometimes I'll deal with debts, for example, where let's say I loan you $500,000 and you're supposed to pay me back and you don't. And I know that you would, but let's say that you don't. Often people get confused. They think, well, hey, can I just go put a lien on his home because he owes me the money? And I'll say, well, maybe eventually, but we have to go get a judgment first. And that means we've got to jump through all these steps, and eventually we've got to go win a judgment, go win a court case. And then once we have the judgment, we can register a lien.
Okay.
The only reason why, in the case that I was just describing, where the buyer or the would-be buyer could register a CPL, is they actually have a proprietary interest in the property. It's not just that they're owed money. It's I actually have an ownership stake in this property. This is my property.
Right.
And so we can lock it up in that respect.
Okay. Now, seller accept an offer. Now, the deal is firm. Now, seller decided, you know what, I don't want to sell. They are in the contract, right? But seller decided, you know what, I'm not going to sell the house.
Yeah, great question. And I see this sometimes, right? Sometimes, especially in a rising market, a seller might sell a home to somebody for $1 million, as an example, and then they look and they realize, wait a minute, this thing's worth 1.2 right now. You know what? I'm not going to close. And maybe I'll go sell it to somebody else for $200,000 more. They take a real risk there, because if the seller fails to close on a firm deal, what the buyer can do is bring an application in Superior Court for something called specific performance, where again, they basically get the court to order the individual, the seller, to sell them the property at the agreed upon purchase price with the same terms. And now that seller is also going to have to at least partially reimburse the buyer for all these legal fees that they've had to incur. So that's the solution in that circumstance.
Now, say another scenario, someone sharing the house, say, mean that is partially tenanted.
Okay.
Right? Now, say basement is tenanted, and now at that time, the closing day, still that tenant is not willing to move, right? So, so in that case, is there any? So they have to go the same procedure like in the other situation?
Yeah. So the buyer, they have a decision to make. Do they take possession of the place and buy it with one tenant still there? And they can do that, and maybe they negotiate an abatement and purchase price, and they can say, listen, this is not what I bargained for. I'm willing to close, but you've got to knock 50 grand off the purchase price or whatever. That's one way you could handle it.
Right.
Or as a buyer, you could say, no, I bought this. It's supposed to be vacant. It's not vacant. I'm not closing, period. Give me back my deposit. And I reserve the right to potentially force you to sell me the property later when it is vacant. So you'd have a couple options there.
Okay. And is there any situation that you come across, say, as example, now the deal is closed, that the buyer got the keys, now buyer walk into the house and someone is living in the house, maybe basement tenant is still not left?
Interesting. I haven't run across that. I mean, obviously it's happened. I haven't come across that. They would effectively now be a landlord, right? And so in terms of getting rid of that tenant, they could potentially bring, that's difficult. Basically, once you inherit a property, whether through purchase or otherwise, the tenant's rights are sacrosanct. Like, they're allowed to live there, right? So long as they're paying their rent, you don't get to remove them unless you can show that someone else is going to be living there, like a purchaser is going to be living there. And so I guess there's two problems if that should happen. One, you have to evict the tenant somehow, which you would now have to do as the owner of the property, which candidly, the way that usually plays out, it's called cash for keys. It's an N11. You get them to sign a document saying, I voluntarily agree to terminate the lease. You pay for their moving fees or whatever and give them some money and they go away. That's how you solve that problem. You also have now the problem of going after the seller because they screwed you over, right? And so you could probably, you're not going to undo the transaction. That wouldn't make sense. But what you are going to do is go sue them for all the costs. So, maybe you planned on Airbnb-ing the basement, or you were going to put your own renters in there with way higher rents, and this has cost you a bunch of money. Well, you'd go sue that seller for, costing you all this money. And you could sue them either in Superior Court, if it's a larger sum of money, or you could sue them in small claims, which has a jurisdictional limit, a monetary limit of $35,000, meaning the most you can sue for in small claims is $35,000.
Okay. The closing day, then buyer walks in. The property has, they agreed to give the broom swept condition. So property has to be very clean and tidy.
Yes, right.
And there are a lot of garbage everywhere. Maybe the dryer or furnace is not properly working. So at that time, what buyer can do?
Yeah, great question. So, most APS, I call it APS, Agreement of Purchase and Sale. Most of them have a couple standardary pieces of wording, namely that the property will be in a good, clean, broom-swept condition, meaning it's not full of garbage or whatever. And sometimes there's also a clause that says that all chattels will be in good working order, meaning the stove works and the dryer works and the fridge works and so on and so forth. And so if a buyer moves in and discovers that's not the case, discovers that there's trash everywhere and nothing works, they could potentially sue them in small claims court for a breach of contract. And so how you handle that really depends on what's it going to cost to make it right. So for example, let's say it's really minor. Let's say that one of the knobs on the oven doesn't work and it's a bit messy, so you have to hire a maid for the day, and your total damages are like $500, a really small amount of money. For something like that, you're going to let it go, right? You're just going to let it slide. It doesn't make any sense. Even if you handle it on your own, it doesn't make sense. And I say that because in small claims court, one, there's no obligation to have a representative, right? You don't have to hire a lawyer to help you in small claims. You're allowed to go represent yourself. But even if you do it on your own, you still have to pay court filing fees, right? Like just to start the claim, it's $100. And if you end up having to go all the way to a trial, you'd have to pay another $300 just to get the trial date. And so if you're fighting over $500, like no one in their right mind would spend $400 in filing fees and a lot of time learning how to litigate and going through the steps, drafting a claim, etc. It wouldn't make sense. So for really small sums of money, you just won't do anything. You take your licks, you move on. If it's a medium-sized amount of money, if it's going to be a few $1,000s, well, then you take them to small claims court on your own. You pay the filing fees on your own, and you download the forms that are available online, and you do your best. Once you start hitting like 10, 15 plus thousand, and again, the limit is 35. So anything from 10 plus thousand to 35,000, in my opinion, that's when it makes sense to hire a representative, right? Now you're fighting over a reasonable sum of money. It makes sense to incur some fees and make sure everything's done properly.
Okay. So very valuable information, Weston. So mostly that people who invested, especially for pre-construction properties, now say they put large sum of money as a deposit. And if they are not able to close, maybe their circumstance has changed or market has changed.
Yeah.
So then what they can do as an investor?
Great question. And sadly, I deal with this all the time. I sometimes have 3 or 4 meetings a day about exactly this problem. Because what we're seeing right now is a lot of the pre-construction closings are happening now for deals that were signed 2, 3, 5 years ago, right? And that was sort of the height of the market. That was when people were paying a fortune for condos in downtown Toronto, for example. And usually, in a long enough time horizon, investing in condos in Toronto it's a good investment typically. Over a long enough time horizon, they inevitably go up in value. But what we've seen is things that were purchased 3 years ago at sort of the top of the market when financing was super cheap during COVID, for example, they haven't appreciated in value. A lot of these buildings are actually worth substantially less, right? So you might have bought a condo 3 or 4 years ago for $1 million, and it might only be worth $800,000 today. And so a reason why a lot of people aren't able to close, it's not just that people are disorganized, it's that they were approved for financing when it was $1 million property. But if it's only, and they're buying it for $1 million, right? But if it's only worth 800 now, well, the bank or the mortgagee, whoever's loaning you the money, they're going to say, yeah, we were loaning against $1 million asset, but it's not $1 million asset anymore. It's an $800,000 asset. So if you want to close on this property, you've got to come up with a shortfall. You've got to come up with the extra $200,000. And most people, candidly, don't have that kind of money. They're not sitting on an extra $200,000. And that's why we're seeing so many people failing to close right now, because the properties aren't worth what they bought them for, and they don't have the extra money to make it happen. So what can they do about it? It depends on the circumstances. In different markets, for example, let's say that, I know this isn't the case, but let's say that prices had appreciated. Prices are considerably up in value, but your circumstances have changed. You lost your job, or there was a death in the family, something horrible happened, you can't afford to close. When properties have appreciated in value, it makes sense to assign them if possible, right? So if I bought a condo for $1 million, but then I lost my job and closing's coming up and I realize I'm not going to be able to afford this, and it's worth 1.2 now. It's actually worth way more than I agreed to pay for it. Well, I'll go assign it to somebody else. I'll go assign it to Gamini, and I'll say, hey, I've got this great deal. I can sell you this condo for $1 million. It's worth 1.2. You make $200,000 like that. What do you say? That's an easy deal, right? That's easy to do. In today's market, we're not seeing that. We're not seeing properties that were bought for $1 million worth 1.2. Now we're seeing property that was bought for $1 million and it's only worth 800,000.
Right.
So no one's going to assign it, right? No one's going to take that deal off your hands. It's not a good deal.
Right.
So assignment doesn't work in today's market, unfortunately. And that only leaves you with a couple options. One, you could just move heaven and earth to make it happen, right? You can go take out a further loan against your primary residence or borrow money from friends or family or whatever and actually close on the property. That's option one. Option two is you fail to close, right? And so I can walk you through, what does that look like? What are the ramifications of doing that? And so every case is different, but I'll just make up an example. Let's say that you bought a pre-construction property for $1 million, and now for whatever reason, you're not able to close. You've put $200,000 down by way of deposits, and you're not going to be able to close. Here's what's going to happen. When you fail to close, the builder or developer will reach out to you and say, hey, you failed to close. We are going to now sell the property to somebody else, and we reserve our right to go after you for any diminishment in sale price. And that's exactly what will happen. So one, you're going to lose your deposit, period, full stop. And by the way, that in our example, it was a $200,000 deposit. It doesn't matter whether the property goes up in value or down in value, that builder is 100% entitled to that deposit. Even if you have the most heartbreaking story of a death in the family or health issues, or you've lost your job, any of a number of horrible scenarios, I've heard them all. Legally speaking, doesn't change your liability. You're going to lose the deposit. Even if they end up selling it later on to somebody else for more money and they haven't actually lost any money on the deal, they still are entitled to the deposit. Unfortunately, you're going to lose your deposit. Then when the developer sells the property eventually to somebody else, I'll give you another example. Let's say that you were supposed to buy it for $1 million, you put $200,000 down, and now they're selling the property to someone for $800,000 because it's gone down in value. Well, the good news is the developer, they are entitled to their damages. They're allowed to sue you for that diminishment in sale price, right? That $200,000 in value that they lost. Yeah. But, and here's where everyone gets this wrong, that $200,000, your deposit is credited towards those damages. Meaning, in our example or hypothetical example, where you bought it for $1 million, now it's worth $800,000, but you paid a $200,000 deposit. Your deposit basically washes the $200,000 loss, right? Mm-hmm. So the developer hasn't actually lost any money, and they can't sue you for any extra money.
Right.
But here's what happens: developers do it anyway. They will, in our example, they will sue that person and say, "Hey, you failed to close. We had to sell it for $200,000 less. So we get your deposit, that $200,000, and we're suing you for the $200,000 that we lost." That's not correct. There's case law where judges have said that's not how it works. You credit the deposit towards the damages. They're basically trying to double dip, right? They're trying to get more money they're entitled to. The reason why they do that is because a lot of people just ignore it. They just ignore it altogether, right? They don't file a defense and they lose automatically. And now there's a $400,000 judgment or a $200,000 judgment against them. And that developer can put liens against their property. They can garnish their bank account. They can garnish their wages. So long story short, if you are in a position where you're unable to close and you are eventually served with a lawsuit, defend it. Or at least at a minimum, go talk to a lawyer, right? Go talk to a lawyer and figure out, where do you stand? How much is your actual liability? Because again, what they ask for in their statement of claim or their lawsuit, it's always more than they're entitled to. Okay. So even though, this is a conversation I have all the time, even though as a buyer who failed to close, you can't win, right? Like the liability is strict. You're going to lose the lawsuit. Mm-hmm. The question isn't whether or not you're going to lose. The question is, how much money should you have to spend at the end of the day? And if you don't fight it at all, well, you'll lose everything. They'll get exactly what they want. Whereas if you defend, no, you're not going to win, but you might save yourself $200,000 as an example. So, and that's where we usually get involved, where we defend these clients and then negotiate with the builder and see if we can get them out for a substantially lesser amount. And those negotiations are all over the map. Sometimes I'm able to settle a file in 2 weeks. Other times they drag on forever. They drag on for a really long time. And sorry, go ahead.
No, it's a very, very timely answer, because most of the people don't know this information what you are sharing, right? They're very scared because builders are always like, pit bull, right? They try to get as much as they can. So what you're trying to say is, if you sign up for $1 million pre-construction property, and if you put $200,000 down, and if a builder was able to sell that unit for $800,000, technically you don't have to pay anything.
Right, because their damages are basically a wash.
Right.
Now, this is far-fetched, but let's say that the damages are even worse than that. You bought it for $1 million, and they have to resell it for $700,000. So they really lost $300,000. Your $200,000 deposit would be credited to that, but you would still owe them another $100,000, right? So they could sue you in that circumstance and potentially be successful. But the amount that you end up paying entirely depends on how much was your deposit and how much has it gone down in value.
Right. Now, we discussed a little further. So the developer cannot sell for less. They have to sell for the market price. They have to prove that they try to get the maximum amount of money for that property, right? I mean,
Yeah, that's a good point. So they do have an obligation to get market value. They don't have an obligation to get the best possible price. This is all very carefully regulated, where they have to get two different appraisals to figure out what the property is actually worth, and they'll list it. So let's say that they go get a couple appraisals, and both appraisals show it's now worth $800,000.
right.
Okay, they'll list it at $800,000, and they'll wait a month and see if they get any offers. If they don't get any offers, well, then they'll reduce it to $750. If they don't get any offers for a month, they'll reduce it to $700, and so on and so forth until someone eventually buys it. Because that's the real market price, right? Something is worth whatever someone else is willing to pay for it. Yeah.
So if they take like 5 months to sell that unit, as example, can they add additional charges like carrying cost and all also?
Yeah, that's a good question. They can. They may not be successful. I mean, they always ask for the stars and the moon, right? They try to get as much money as they possibly can, and they'll try to say, well, we've got our own carrying costs. We borrowed this money at some exorbitant rate, and they should have to pay us. Whether or not they're successful on that really depends on the case. Sometimes they are, sometimes they're not. It's very dependent. The one thing that's clear, though, is that the would-be buyer, the failed buyer, is always responsible for the diminishment in value. There might be extra charges, but at a minimum, they're going to be held responsible for that diminishment.
Okay. Let's say I'll take another point. So they bought for $1 million, and they put 200,000 as a down payment. Now at closing, they are not able to close for different reason. Now the builder sold that property for 900,000. Will they get that 100,000 back?
Yeah, good question. So no, unfortunately, the deposit, while it is credited towards damages, it's effectively a guarantee for performance. So in our example your example where we put $200,000 down, it's only gone down in value 100.
Right.
So actually the builder is $100,000 ahead, right? They're doing really well in this deal.
Yeah.
In that circumstance, they're still 100% entitled to the deposit. And this might surprise people, but even in our example where, I'll give you a new example. You agreed to buy it for $1 million. You put $200,000 down. It's now worth $1.2 million. It's worth way more money. They're going to go sell it to somebody else, and they're going to make a lot of money. Believe it or not, they're still entitled to that deposit 100%. So no, long story short, if you fail to close, you are losing that deposit. Legally speaking, you are not entitled to it.
Okay. As a buyer, I think that's why it's very important to do a financial analysis and understand how much house they can buy. And that is very, very important, right? So I think that's why they have to work with a really good agent who can understand the numbers and who can give you the people should buy what they can buy, right? Yeah. So I think, Weston, you share a lot of information. I think most of the people are not aware, because especially in today's market, a lot of investors out there, they'll freak out because of the market condition.
Yeah.
But I think definitely what you share with people is really helpful, and so they can contact you, and this is the best number to contact you.
Yeah, so that's the general line for our office. And in terms of next steps, if people have problems, which inevitably they will,
Right.
By all means, give us a call, and my legal assistants will confirm it's a problem that we're able to solve for you. And if they think that it is, they'll schedule you in for a consultation where you can speak with a lawyer, go into depth about your scenario.
And I have another question, if you can help me with that. So if someone couple is going through a divorce, what advice you can give to those people? I know there are situations that they are in, regarding the real estate.
Yeah. So I don't do family law, for example. I don't help people get divorced or anything like that. Mm-hmm. But this does happen sometimes when a husband and wife agree, okay, we're going to buy a rental property, we're going to buy a condo to rent it out, and then their marriage breaks down and things get really complicated. They should, so far as possible, have a unified front, right? So if you made an agreement that you were going to buy a condo, understand that either one of you can blow this deal up, right? And if one of you blows it up and the other one was ready, willing, and able to close, let's give an example. My wife and I are great, but let's say for whatever reason it doesn't work out, and we were going to buy a house together, and then right before closing, our marriage sort of dissolves or whatever. If I'm ready, willing, and able to close, but she for whatever reason pulls the plug, well, one, we're both going to lose our deposit, and we're probably both going to get sued. And my wife has to be especially careful now, because I could actually cross claim against her, and I could say, listen, any money that I'm held responsible for in this blown up deal, you're going to have to reimburse me because I was ready, willing, and able to close. This was all, your fault. So in that circumstance, both parties, the man and the woman, or whatever the case may be, they're going to need their own separate representation, right? They're going to need their own litigation lawyer, and hopefully they can get it together and go through with the deal, because that's usually the best case scenario for everybody.
Okay, good. Great answer.
Meaning one quick thing I'll leave you with, just because I think you deal with a lot of investors, and investors should know this. In any pre-sale agreement where they're buying a pre-construction condo, there's always 4 dates, right? You're familiar with this, and one of those dates is the outside occupancy date by which the developer has to be able to provide you with the property and close. And they're usually really long dates, right? Like they have quite a bit of time. But I do see from time to time, developers who go over those dates, who miss the outside occupancy date, where, they had 4 years to build this thing.
Yeah.
And for whatever reason, they're just not able to finish it. What a lot of people don't understand is, if a developer misses that outside occupancy date, they said, 4 years ago, they said, at the very latest, our outside occupancy date is going to be 4 years from now. And then 4 years go by and they fail to close. Your investors, they've only got a 30-day window from that outside occupancy date. They've only got 30 days to put something in writing to the developer saying, hey, you missed the outside occupancy date, so I'm terminating the agreement, and I want my deposit back, and I want interest, and I want delayed occupancy. And they'd be entitled to it. But if they wait 2 months, for example, they're stuck, because the rule is very clear that you have to do that within 30 days. So long story short, all your investor clients should be looking at those outside occupancy dates and seeing, hey, did they miss it? And if so, diarize your calendar so that if, God forbid, it comes to that, you make sure that you're making that claim, you're making that choice to terminate the agreement, that you're doing it within that 30 days. Because if you wait too long, you'll be out of options. And it breaks my heart when people come to me and say, yeah, the outside occupancy date was 3 months ago. And I say, I wish I'd met you 3 months ago. I'd be able to help you. But now you're sort of stuck.
So you said that, can they extend that date for a couple of times? Developer has right to extend?
Yeah, so a developer usually gives 4 dates. Preliminary closing date, and then there's a second date, and there's a third date, and then there's an outside occupancy date.
Right.
And we actually did see during COVID, they can actually extend these dates unilaterally if there's a COVID or a pandemic, something highly unusual. But that's very unusual. Typically, your outside occupancy date is it, period. That's it.
Yes.
And so if they fail to miss that date, then usually the buyer should be able to elect, that's the word I was looking for. They should be able to elect to terminate the agreement, but they've got to make that election within 30 days.
Okay. So if they are in a losing situation, they should elect this.
Yeah, and I've fortunately I've been able to help some people where they bought a condo for $1 million.
Right.
It's now worth $800,000, and it's not quite finished yet. And the builder has missed the outside occupancy date, and I've been able to help my clients say, "Well, we're done, right? Thank you very much. We'll take our money back," and it's great. Like, it's the best possible thing.
I think this is a great advice. I think most of the people, not aware of what you are saying.